in a chat, and if I have my screen set up correctly, I'll be able to see that. Let me go over the questions that we've received ahead of time. The first one is, if I'm sued, can a collection lawyer make my husband leave the courtroom? Then we have, how can a court accept or allow a lawsuit for debts when the statute of limitations has expired? And then, what is the statute of limitation on car loans? And this is where somebody is sued by debt buyers such as AutoVest or Cascade Capital. And then we have, is it possible to win a National Collegiate, and that's a student loan type of case? And then, why did National Collegiate Student Loan Trust sue my dad, who was a co-signer on my student loan? And then the final one is, how to stop a debt collector who is calling, but they're really looking for somebody else. So those will be our questions. We'll run through those. If you have any additional questions, like I said, you should be able to type those into the chat function, or just leave us a comment or get with us directly here on YouTube or at alabamaconsumer.com, and we'll get your question answered next time. So we'll go ahead and get started. First question is, if I'm sued, can the collection lawyer make my husband leave the courtroom? So the short answer is yes, or at least usually. So you've been sued, you filed your answer, you're now in court, whether it's small claims or district court or circuit court, and there's some debt buyer that's there. So it could be Midland Funding, Portfolio, Calvary, Unifund, whoever it may be. And the lawyer notices that your spouse is there with you. Well, they may want to separate you just for psychological purposes to try to bring pressure on you so that you won't feel comfortable. And then maybe you'll panic, or maybe you'll get real nervous and ultimately pay them money that you don't have to pay. So there is a concept of the rule. And that simply means that anybody that is a potential witness can be forced to leave the courtroom so that they're not listening to the other testimony, and that's not influencing them. Now, I'll say this. The collection lawyer probably has no intention of calling your spouse, but they may do that just to make your spouse leave. So what's the solution? Well, the solution is, if you're going to handle this on your own, and you have 5 options when you're sued by a debt collector. We have all sorts of videos on those. But if you're going to handle this on your own, just understand that, first of all, your spouse, unless your spouse is a lawyer, cannot speak in the courtroom, cannot ask you questions, can't make arguments to the judge, and they may not even be able to be sitting in there while you're trying your case. So it is not a reason to pay the debt collector money just because they'll make your spouse leave. But you need to be aware of it. So again, it's not a surprise, and it doesn't kind of get us off balance when we're there trying to get ready for our trial. Okay, so our next question is, how can a court allow lawsuits for debts when the statute of limitations has expired? It's a great question. A lot of controversy over, well, what is statute of limitation in Alabama? Is it 3 years? Is it 4 years? Is it 6 years? What is it? Well, whatever it is, there are many lawsuits that are filed that are after the statute of limitations has expired. So the person that asked this question is going, well, what are the courts doing? Why do they allow this to happen? And the simple answer is that when you're sued in state court, the state court judge is expecting you, the defendant, to raise as a defense the statute of limitation. So Midland, Portfolio, whoever it is, boom, they sue you. Well, you've got to file your answer and say, hey, judge, statute of limitations has expired. Okay. Now, there are other defenses to put, and really between you and me, statute of limitation is not nearly the best defense that you have, but it's a valid defense. Now, let's talk about these debt collectors. If they sue you after the statute of limitations has expired, then normally we can sue them in federal court for doing that. So go back to the question, why do courts allow this? Well, state court is going to allow it, but you need to file your answer or get a lawyer to file your answer and raise that statute of limitation and then prove it at trial. But another way to stop it is you sue these guys in federal court. You sue them for the only thing that matters to them, money damages. That will get their attention. That will get them to go, maybe we shouldn't do this in Alabama because the amount of money we're paying out is more than we're getting in filing these bogus lawsuits after the statute of limitations has expired. So hopefully that answers that question. Our next question is, what is the statute of limitation on a car loan? And here's what the person means by that. So you have a car loan and the car company says you defaulted on that loan. It might have been with Santander, Citibank, Capital One Auto, whoever it may be. And now some debt buyer. AutoVest is a big one. Cascade Capital LLC, that's kind of a new one for us in Alabama, at least in terms of the volume that they're now filing. And so they come along and sue you. And they typically will sue well after the statute of limitations. So let's talk about this. On a car loan, not every car loan, but almost every car loan that we see anyway, statute of limitations is actually 4 years. Okay. Now in Alabama, typically a breach of contract is going to be 6 years, but these car loans are governed by a different law. So normally it's 4 years. Well, when does that 4 years start? Well, it normally starts when you miss your payments. And it certainly starts when they repo the car and they say, hey, it is all due right now. Okay. You can't keep making payments every month, starting this month and this month. No, it's all due right now. Well, then if you don't pay it right now, then that's going to start statute of limitation. And so typically, here's what we see. We'll have a lawsuit, let's say Cascade files a lawsuit in October 2015. And so you may now just be getting served with it. And it'll be for a repossession from back in, say, 2008. And so after the repossession, then they sell the car, then they write you a letter. It says, hey, you owed $15,000. We sold your car for $5,000, so you owe us $10,000. Well, statute of limitation really would have started before then, but certainly at that point, it starts. We've got 4 years. They need to be suing you in 2012, not 2015. And so what does that mean? It means you have a valid defense, say, you sued me too late. Now, again, with AutoVest, Cascade, the other defense is you don't even own the debt. You know, you're this debt buyer. You're suing me. You claim you owe it or own it, but you really don't own it. Okay. Or, they'll say, oh, yeah, we know we own it. And then they come to court and they don't prove it. So I don't really care whether they owned it and they just refused to prove it, or they never owned it and they could not prove it. It really doesn't matter to me, because the point is when you sue somebody, you have to prove your case. So you've got that defense, you got statute of limitation defense, and then what you do is you look at suing them in federal court. Again, money damages. That's what will get their attention and get them thinking, maybe we shouldn't do this in Alabama. So if you've been sued by AutoVest, Cascade Capital, there's a whole bunch of these places, and it's on a car loan, definitely check out your rights on that. Okay, our next question, actually next two questions are with National Collegiate. So the first question is it possible to win a National Collegiate case or National Collegiate Student Loan Trust case? Sometimes you see it worded one way, sometimes the other way. The answer is yes. Any of these cases, it is certainly possible, and it may even be probable to win these cases, because you never borrowed money from National Collegiate or National Collegiate Student Loan Trust 2006-4 or whatever they describe themselves as. So you borrowed it from Charter Bank or Bank One or whoever it is, and then that bank supposedly transfers it over here, and they transfer it to some place called Marblehead, who transfers it to NCO, who transfers it. There's all these different steps in the way. Well, they have to prove those, okay? So they'll send somebody from NCO, which is a huge debt collector, and they'll say, oh, we are the custodian for National Collegiate Student Loan Trust 2006-15 or whatever. Really, you're the custodian. What personal knowledge do you have? Well, this is what I do. I go around and say I have personal knowledge, okay? So have they proven that who you took the loan out, that went here, ultimately ends up with National Collegiate or National Collegiate Student Loan Trust, and they can prove they're entitled to the money. Well, if they can do that, then they win, unless you have a valid defense like statute of limitation. But a lot of times they don't do that. They won't do it. They can't do it. Again, I don't really care. The fact is, when you're in court, the time to talk is over. The time to prove is now in court. And so if they don't do that, they lose. And then, as you can imagine, if you lose one of these cases, there's a lot of consequences. Credit reports, with what do you do when a bogus lawsuit's been filed against you? Do we go sue this company in federal court? All sorts of consequences. Now, the kind of follow-up, or not really follow-up, but I guess the related question is, why did National Collegiate Student Loan Trust sue my dad, who was a cosigner on my student loan? Well, the short answer is they'd rather have two people to try to get money from rather than just one. And the theory is that if we have the student here and the parent is 40 or 50 or however old, 60 years old when the student's taking out that money, they're probably in a better financial position than the student who's maybe 18, 19 years old and just starting their education. So the idea is the parent is probably higher net worth. They've got more assets. Maybe they have a better job. We see so many young people that they maybe have 100,000, 150,000 in private student loans, and they're making $24,000 a year. That's $2,000 a month without any taxes, any deductions. $2,000 a month, there's no way you can service $150,000 worth of debt. But your parents might be making $6,000, $10,000 a month. So if they get sued and lose 25% of their wages being garnished, it's a lot of pressure. And so that's why they would sue the cosigner. Usually it's a parent, sometimes it's a sibling, a lot of times it's even a grandparent. And grandparent may only get Social Security, which they really can't touch, but maybe your grandparents have a house that's paid for. Well, you put a lien on that house, they can even sell that house. So very important, if you're sued by National Collegiate or National Collegiate Student Loan Trust, definitely want to find out your options. We have a long video just on that I'm sure we'll link to it in this, or you can find it on our YouTube channel or on alabamaconsumer.com. All right, so our final question is, how do I stop a debt collector from calling me when they're really looking for somebody else? So it's a great question, and it's something that we get quite a bit. So, here's my cell phone. I'm getting a call, and I look down at it. I go, I don't recognize that number, so I answer it, and they go, yes, we need Josh Smith. Well, I'm not Josh Smith. And they go, how do we know you're not Josh Smith? Well, I know I'm not Josh Smith. Then I'm telling you, I'm not Josh Smith. My name is John Watts. They go, yeah, but you know a Josh Smith. I don't know. They go, well, we got this number somehow. You're responsible to help us find Josh Smith. I don't know a Josh Smith. And then ultimately you end it by saying, you know what? Don't ever call me again. Okay, so that's annoying, and you probably don't make a note of it because you think, well, it's never going to happen again. Maybe the next hour, the next day, phone rings, you look down at it, go, wait a minute, that's that place they called me before. You answer it, they go, yes, Josh Smith. You're like, I'm not Josh Smith. And I think we had this phone call yesterday. They go, well, our information is that you are Josh Smith. I'm not. You're wrong. Okay. My name is John White. I'm not Josh Smith. And they keep calling and calling and calling. And, how do you stop it? Well, some people will put an app or somehow block that phone number. They'll just get another phone number to come around that app or that block. So here's the real solution to it is you sue that company in federal court. And when they get sued, and so they get this lawsuit, they get in their hands and it says, continue to call the plaintiff, and plaintiff told them it had the wrong number. They continue to call over and over and over and over. And then they go, oh, wow, we got to go hire a law firm. So in Birmingham, Alabama, that's typically Burr Foreman, or Neil Moore is a lawyer that defends these. Boss Bingham sometimes defends these around the state. So there's 4 or 5 lawyers that defend these around the state. They go, okay, well, we got to go hire those lawyers. We got to pay them money. And if we lose, we got to pay the consumer more money. And if we lose, we got to pay the consumer's lawyer money. And so that tends to motivate them, get them thinking to go, maybe we should first stop calling this consumer who's now sued us. And second, why don't we make this thing right? Let's go to them, make them a fair offer to compensate them for what's happened. Okay, so that's fine. That's the way it's supposed to work. Sometimes they don't do it, and hey, that just makes the amount they have to pay more and more. But here's what's really supposed to happen. They're supposed to have this thought and go, when we call people in Alabama and we get the wrong person and they tell us we got the wrong person, maybe we should stop calling them. Maybe we shouldn't keep blowing up their phone 2, 3, 4, 5, 6 times a day for the wrong person. And see, if they call your cell phone, that may be the TCPA, Telephone Consumer Protection Act, which can be $500 or $1,500 per call. Okay. Now, they also violate the FDCPA, Fair Debt Collection Practices Act. So you want them thinking, going, it's really getting expensive. I have to keep paying out all this money. Maybe we should stop doing this. That's the whole point of the law, is to protect you and to protect the collection agencies, the debt collectors that do follow the law. Because it's really not fair for, let's say, portfolio recovery. If they keep calling you and calling you and calling you, that's not fair to XYZ collection agency that they call you. You say, you got the wrong number. They go, we're so sorry. We'll never bother you again. See, portfolio or whoever's breaking the law, they get this great competitive advantage because they're breaking the law. So when you sue them and they have to pay out money, we're trying to take away that competitive advantage and say, no. You do not want to do this. Stop. Follow the law. Well, listen, I hope that this has been helpful. I don't see any written questions. Feel free to send those to us. You can leave a comment below. You can go to alabamaconsumer.com, leave a comment. You can reach out to us directly. Our phone number is 205-879-2447. And we'll look forward to doing this again. And please keep the questions coming. That's how we get these questions. So we appreciate it. And if I can ever be of help to you, main website is alabamaconsumer.com. And you can also call us at 205-879-2447 and ask to speak to Carolyn. She can take down your information, figure out what's going on, then she'll set up a call, sometimes an in-person meeting, but usually we can do it by call, so it's very convenient for you. So hope you have a great weekend, and thanks for watching. Okay, bye-bye.